Okay, so this morning I'll be talking to you all about the bill to introduce this session to ban the use of the odor of marijuana to begin police encounters, which is really important because this is how a lot of police intrusions that either end in some type of arrest or don't end in any type of arrest, but do cause harassment and can really lead to violence and death in our communities. A lot of them begin based on the odor of marijuana. So first, I wanted to give y'all an overview of the law of cannabis and of the Fourth Amendment, because I think there's a lot of confusion in terms of what we're talking about that this would even govern. So under the Fourth Amendment, everyone has a right to be free from an unreasonable search and seizure by the government. So there are really three levels of police intrusions that can take place, and there are different legal standards along the way. So the first is a consensual encounter, which the Fourth Amendment does not protect you from. And so if an officer comes up on the street to you and says, "Hi, how are you doing?" and you start talking to them, that is a consensual encounter. A stop an officer has to have reasonable suspicion that you are engaged in criminal activity, and that is a stop. It's supposed to be a brief detention, asking questions to either confirm or dispel a belief that you are engaged in some type of criminal conduct. And an arrest, an officer has to have probable cause, so really 50% plus one belief that you have engaged in some type of crime, and this is really a full detention. So then on the bottom, we have the timeline of what has happened with marijuana over really the past almost decade. So prior to 2014, all forms of cannabis were illegal, and that meant that it could be used to justify any type of police intrusion if they saw it or if they smelled it. In 2014, we know that marijuana less than 10 grams was decriminalized, and that really started a lot of litigation over what the odor of marijuana and possession of marijuana could mean in the criminal context if there was an amount that wasn't a criminal amount to possess. The first of three cases that are really important to think about what the scope of the law is Robinson versus State, which was in 2017, which allowed police to search a vehicle based on the odor of marijuana alone. And that's because of something called the Carroll Doctrine, which is a case that comes out of the Prohibition era, where the courts were concerned about trafficking and bootlegging of alcohol, right? And so they really expanded police ability to search cars if they believed you were carrying something that was criminal or contraband. And so since less than 10 grams of marijuana remained contraband, that meant that your vehicles could still be searched even after decriminalization. In 2018, hemp was legalized, and our office did a lot of and has pushed a lot of litigation around the theory that because hemp and marijuana are indistinguishable in terms of smell, that therefore police can't use odor to infringe on individuals' Fourth Amendment rights, but the courts have really not had an appetite for adopting that theory. In 2020, Lewis versus State held that officers cannot arrest an individual based on the odor of marijuana alone, and that's because the odor of marijuana alone doesn't denote a criminal amount. And so in order to arrest, I have to have probable cause, 50% plus one, belief that you're engaged in criminal activity. But if I can't tell how much marijuana you have, I have no basis to really believe that you're committing a crime and that you have greater than 10 grams on your person. So under that theory, we challenged reasonable suspicion for a stop in June 2022, my case in Ray DD. And unfortunately, the court went the other direction and said, but still the odor of marijuana allows police to stop individuals on the street because the odor of marijuana can still indicate something criminal. And in the Terry analysis, which is the stop, that middle analysis, police don't have to adopt every innocent explanation for conduct. Conduct that is legal can still add up to criminal activity. And so that's how we got that holding there. And then obviously in November, the voters voted to partially legalize cannabis, which is part of why we are going to continue to run into issues if we don't pass legislation this session. So under the current state of law, what can the police do based on the odor of marijuana? Well, they can still stop and search your vehicle, and they can still stop and question you on the street, but they cannot place you under arrest. So why is this a problem? Doesn't legalization just fix all of this? And the answer is no. Because the underlying rationale for DD and Robinson is that because marijuana in some amount remains criminal and some amount remains contraband, that therefore it can still play a role in the Fourth Amendment analysis, unless we were to eliminate all criminal and civil penalties for marijuana and completely legalize marijuana, that justification will still exist. So as long as we have, I think the threshold is 2.5 ounces, the same rationale can apply that we don't know based on the odor of marijuana if you have greater than or less than 2.5 ounces of marijuana on your person, and therefore it can still be a basis for a stop. Or search of your vehicle. And as I mentioned earlier, under the Fourth Amendment, individual doing legal things can still add up to reasonable suspicion of criminal activity. So legalization alone doesn't fix the problem. Second, is that racial profiling in traffic stops is totally okay under the law. There's a case called Wren that is from the Supreme Court in the 90s that says, yeah, an officer's subjective intent can be to just pull you over because you're Black, but if you've committed a traffic violation, then they can still pull you over because you're Black. And what we see in the data, and there's a really great race-based police stops dashboard that the state of Maryland keeps. In 2021, Black people were nearly 41% of all traffic stops versus being 31.4% of the population, so obviously overrepresented. And as you can see in this graphic down here, probable cause was used to justify 76% of all searches of Black people. Now, what's important is that we don't know, breaking down of that number, the number of times that police said, I smell marijuana, and so therefore I have probable cause to search this vehicle. The data doesn't show that. And there's so many stops and searches of vehicles that take place every day that are based on the odor of marijuana that we don't know about, which leads to the third point, is that no one can prove whether an officer actually smelled cannabis or not. So if an officer searches your vehicle because they said they smelled marijuana and they don't find any marijuana, nothing happens to them. There's no consequence to that. And so regularly and routinely, officers use the odor of marijuana as a basis to search vehicles in particular, and then to hope to find something else. And ultimately, we have body cameras, but we don't have smell cameras, right? So there's no way to verify or not whether any of that ever occurred. So the solution is the bill that we are introducing this session, which would importantly prohibit officers from using the odor of raw or burnt cannabis, possession or suspicion of possession of cannabis, or the presence of cannabis in proximity to money as reasonable suspicion or probable cause to commit one of these Fourth Amendment intrusions. So this, again, will really limit police being able to use the odor of marijuana as the beginning of any type of police encounter. Two really important points. First, I know Mohammed had a question about this earlier. There's a carve out for using the odor of these factors in a GUI analysis. There isn't really data that supports that, this driving while high notion, but this was something that was really important, came out last session. And so there is a subsection that allows some use of odor and these other factors in the DUI analysis. Second is that if evidence is seized in contravention to subsection A, then that cannot be admitted in a trial, hearing, or other proceeding, right? And so the only way to actually change police conduct is to have there be some type of consequence for it. And so if all of a sudden all of these stops and searches that were being justified based on the odor of marijuana alone are not held up in court, then the police will have to use some other investigative tool or stop harassing people based on the odor of marijuana alone. Importantly, Virginia and New York passed legislation that looks similar to this when they legalized marijuana. And in every other state, this has had to be resolved through litigation. And so the reason why this is so essential to pass this session is because otherwise we will spend the next almost a decade, as we just did with decriminalization, litigating this in courts. And because, again, we talked about the underlying legal reasoning that exists already in our case law, we're likely to lose those fights, I think, in the long term, or it will be really difficult for us to win. The Office of the Attorney General offered an advisory opinion to the leaders of the General Assembly, really laying out this same theory as well. And so if we don't codify this, we will be fighting this in the courts for the next decade. People, and Black people in particular, are going to continue to be stopped, searched, harassed, and criminalized for conduct that is legalized. And really, legalization means nothing if it is not accessible to everyone, and it's not still used to justify intrusions in Black and Brown and poor communities. So that's why this bill is so essential.